Great. We're going to go ahead and get started. There's not an empty seat up here. Well, there is an empty seat, but Mark is joining us via Skype. He'll be up here in just one moment. First, I want to welcome you to our event today, Medical Data Innovation, Building the Foundations of the Health Information Economy. My name is Daniel Castro. I'm a senior analyst here at the Information Technology and Innovation Foundation. For those of you that don't know ITIF, we're a nonprofit, nonpartisan public policy think tank. I think we've really been one of the leaders among think tanks in promoting the idea that IT has powerful opportunities to transform industries. And in healthcare in particular, IT can be used to not just enable all these great gains in efficiency, but to really unlock medical data, to enable new types of research and services that can lead to vast improvements for patients. I think one problem is that we see, even with all the significant amounts of investment that we've seen in the past few years in health IT, we're really not yet on a path to harness all of this potential data for new uses. And when you look at different industries, I think you'll see that this is indicative of a larger problem that we have in the policy space, and that's that policymakers don't really always understand that you need information to have an information economy. And you see this reflected in various proposals to limit data collection and limit data use, whether it's in healthcare, online commerce, utilities, or most recently in mobile device tracking. And many of these limitations, of course, come under the guise of consumer privacy protections. Of course, some of those are valid and some of those aren't. And the purpose of today's event is really to discuss the role of data-driven innovation in healthcare, to look at questions, to understand what the current practices are, what are the opportunities for this in the future going forward, and how can policy help shape this industry, and in some ways, how can policy help foster this industry? And then, of course, we're also here today because of the recent Supreme Court case, where oral arguments were heard last week. The case is pending right now. The challenge is the constitutionality of some of these state laws that restrict the use of prescriber-identified data. So what are the implications of this case for healthcare, for data collection, and for free speech? We have a fantastic panel today. First, we'll be hearing from Dr Adwan, who's a professor of law at Suffolk University Law School. He's published extensively on the relationship between law, ethics, markets, and healthcare. He's the author of Medicine, Money, and Morals, Physicians, Conflicts of Interest, and a lot of squeaking here. And also the most recent book, Conflicts of Interest in the Future of Medicine, the United States, France, and Japan. Then we'll hear from Kathy Betts right here on my left, who's the Vice President of Government Affairs at Walter Kluwer's Pharma Solutions. She has over 25 years experience in government affairs and legislative issues, and she's a internationally recognized expert on health policy and health law issues. And finally, we'll be hearing from Ann Waldo, who's a partner in the law firm Whitty, Letch & Waldo, which focuses on privacy, information security, and healthcare issues. She represented Genetic Alliance in an amicus brief that was filed in this recent Supreme Court case. And she was formerly the Global Chief Privacy Officer for Lenovo, and has extensive experience and background in healthcare and consumer privacy issues in the consumer space and in the private sector. So in terms of logistics, what we're going to do is each panelist will spend about 15 minutes, and then we'll get into lots of discussion and Q&A. And of course, we'll try and end exactly at 4:30. So Mark, you're up. You're on the screen right now.
Okay.
And I'm
Can you hear me?
To you. Go ahead. Yes.
Do you hear me?
Yep. I think you're good.
Okay, fine. Okay. So I'm going to look at some larger issues on access to data that are beyond the case, particularly about access rights as defined by ownership. And why don't we switch to the PowerPoints now, or make that available?
Yeah, and I'll just interrupt here. All the PowerPoint slides for Mark were at the entrance if you don't have the paper copies.
Okay. So for those that want the full argument, I've listed 3 places to get it. A short summary in JAMA, a law review article that goes more into the law and economics and an SSRN, which is available, downloadable for free. The creation of this electronic medical record raises new issues because we can tap patient data much more easily, but there are also some obstacles, particularly about privacy issues. Let me briefly just point out what's at stake. I think probably most of you are aware that with national longitudinal data, we'd be able to monitor and respond to public health problems the way we can't now. Just for example, we could track adverse drug reactions. In theory, instead of waiting till spontaneous reports come in, one could issue an inquiry, see if there was a particular drug that had adverse reactions based on data, and then drill down and see if there was something really there or not. The problem is, from my perspective, that the current law leaves us in limbo. Medical records are treated as physical properties that are owned by doctors and hospitals, but insurers and patients have access to the records. The providers don't have exclusive ownership of the data. On the other hand, they have a right to use it. Now, what the current law doesn't do is say who owns the data as opposed to the record. In practice, organizations that have access to data sell it so long as they comply with the HIPAA and other standards. And when the data is anonymized, they do so, but they often try to restrict access to commercialize its use. And the status of doing this is uncertain. Certainly, we don't grant under the current law intellectual property rights in anonymized patients' data that they created from a medical record. Only original creations are granted ownership rights. So even if there's not ownership interests, what a lot of firms do is try to limit use of their databases, try to encode it, try to encrypt it, and the like. So in effect, it has often been privatized by contract. Now, normally, our reaction might be that this is a good thing. Property rights give incentives to invest and create value, and we want to protect it. But my argument is that treating anonymized patient data generated from billing records and patient records is a different case. And in fact, treating it as private property would preclude forming comprehensive databases required for public health and safety uses. What's most valuable for this kind of data for public health is a large database so you can identify large trends. And that requires an aggregate database. The other problem from private ownership is that it would allow monopolies, the owners, and they could limit the market not only in the derived the services, but with the data. So they'd have a link in, and if you wanted the analysis and the benefits of making use of the data, you had to buy their data. Whereas if this data was in a public form, you could have competition and multiple users. An analyst could use it, and they could commercialize only the result. So, similarly, the argument that you have to create incentives for people to invest, as it exists in many intellectual property areas, really doesn't hold here, because we're not talking about generating or creating new data. We're talking about data that already exists in medical records and billing records that people are obligated to collect and report for medical practice standards and billing, and it's going to be collected whether or not it don't. It has been in the past. So you don't really need to privatize this data to generate its use function. Now, the other problem is you might say, well, still, why should you have this as a public entity? We have a tradition of doing things through the private sector in this country. And the issue here is that the privatization will actually limit its development, in my view. And that is because you're going to fracture the database of data. You'll have different owners, each trying to sell their part. And that private ownership is going to be much less valuable than if you had databases that were aggregate, national, or regional, and then subdivided by different users as their use. And so the question is, can you get to a private market in ownership those aggregate uses? Now, the conventional wisdom has been that you should deal with this through private markets. I want to cite the 2006 Heritage Foundation report that advocates private ownership of anonymized patient data, and also states that governmental authorities should have to purchase this from private entities on the same term as other parties. Similarly, AMIA in 2007 advocated that stakeholders should adopt guidelines with shared access, and they suggested we shouldn't talk about ownership. But it's notable that in their list of stakeholders, they didn't mention public authorities. They mentioned insurers, companies, data banks, and patients. And I think there are certain things that can only be done or need to be done by public health authorities, and that they should, if anything, have a privilege of positions. The current way to deal with this is to have voluntary standards, but those who draft the standards as stakeholders have very different interests from, say, the public health authorities, and it's going to reflect that. There's a lot of money at stake. IMS itself makes over $2 billion a year selling data, and this kind of market is going to increase. Now, least you think I'm against private ownership, private property, and am some kind of advocate of Sovietization. Let me suggest that I'm all for private markets and private development, but that to do that effectively, you have to have public aggregation as a prelude to the private development. So first of all, there's a literature on network effects. And this literature suggests that basically certain kind of activities in networks produce more value when they grow as opposed to the reverse. And patient data is an example of that. Data from one health plan has some value. It's much more value if you have it across health plans and the nation. So how do we get to it? Well, I suggest a reporting requirement as we have in other areas that's national, and that would be incredibly efficient, whereas the alternative is to have multiple groups seek out, purchase, negotiate price, bargain to get data and aggregate it. And that's going to be not only having a high transaction cost, it's also going to be leading to limits in terms of exclusive use or sales at prices that preclude others. Furthermore, markets are likely to tap not all the data, but to focus on data that's most commercially viable. And the problem there is, once you have that out, it's much less incentive or much less cost to tap that other data that's left. And you may well have private groups closing off data and not collecting it to protect themselves. So what's the evidence that that's going to be an issue? Well, in fact, we have a lot of evidence. Let's take a look at one area. The TRIPS agreement restricts clinical trial data used by generic competitors. That's well and good. But what we found is that it not only has that effect, it conceals information on health risks. And so even with a good motive, there's some collateral problems. And we've also found that many drug firms delayed or blocked disclosure of research data on health risks. That led to the creation of clinical trial registries. And there's a fair amount of evidence that firms use data selectively as a competitive tool. So I don't think it's reasonable to assume that the market naturally will produce sharing of data extensively. It might produce a lot, it might produce some, but there'll be significant limits on it. Let's take a couple of other examples where privatization has led to some problems. This is what's sometimes called anti-common problems, patent thickets, holdouts. There's a great literature on this, and it's sometimes referred to as the opposite of the tragedy of the commons, referred to as the anti-commons problem. The tragedy of the commons is when lack of regulation or private ownership leads to overuse of resources and non-investment, and privatization is one way to overcome that. The anti-commons problem is the reverse, fracturing of property rights into too many small parts so that no one entity has the power, the entity, the resources to collect them. And there's a literature that's shown that this happened in post-Soviet Russia. There's a literature that suggests in patents and biomedical research this can happen. It gives blocking power to individuals that will not sell the data or held out for much more. So, in theory, it's possible to get cooperation by creating joint ownership arrangements and privately contracting and giving all stakeholders an interest. But that just means it's possible to do, not that it will happen. If in turn we had the creation of a public database through a governmental or a governmental, quasi-governmental entity, which then released the data, you could get efficient aggregation, perhaps some standard for privacy, access to the public health authorities for monitoring public health problems and perhaps system oversight, fraud, abuse, and then produce at a low cost data that independent firms could use, develop, and tap through their software, their analysis, their presentation, that would have great use. And so I see the best of both worlds through the public initial creation of this database that then rewards the truly creative activity of those who use it. And this has been overlooked by a lot of firms that are pushing to tap the short term, but I think they ought to be thinking about that. And there's one final point. I think I'm about at my end. We've often think about privacy as a way, private ownership as a way to protect privacy rights, or at least some people do. And there's a whole literature on this that I address with my paper. My view is that whether you call it private or public, there are serious privacy concerns, even for what's called de-identified and anonymized data, that they're not necessarily easier to deal with when there's private ownership and not public ownership, and that we have to address this. And just in support of that, let me say we now sell this private data, and as far as I know, there's very little in terms of limiting of access to it now in the private sector, and I don't see why there'd be more of a problem if it was initially publicly collected. Can I have one more minute for a final point?
30 seconds.
30 seconds.
All right.
There's precedents. California requires reporting of hospital discharge data. Massachusetts has an all-payer database. We have census reporting. We have SEC reporting. There are lots of areas where we've asked for public reporting of data, and it serves a great public good. So this is not totally new. We've done it in the Medicare program, and I think that I'll end there and let the others speak, and thank you.
Thank you, Mark. I'll go ahead and turn it over to Kathy. Thanks.
Great. Okay. Great. Thank you, Dan, for inviting me to present today. Dr. Adwan presented a very interesting idea in a galaxy far, far away. I think we shall stick with our business model. It's a very competitive market. There are basically 3 companies who compete in the HIPAA de-identified prescriber data market. That's IMS Health, SDI Health, and Wolters Kluwer Pharma Solutions. For those of you who don't know, Wolters Kluwer is a worldwide publishing company. We publish textbooks, online content, research, all sorts of publications, and we specialize in information, if you will. Our Wolters Kluwer Health and Pharma Solutions division is a leading provider of information and business intelligence for students, professionals, and institutions in the healthcare space. We publish all sorts of medical journals, online content. You may have heard of some of our brands: ATIS, Clinic Guide, Facts and Comparisons, Lippincott, Williams and Wilkins, Metaspan, Ovid, Provation Medical, and it's our source healthcare analytics line that is the prescriber data product and service, if you will, that's we're talking about most today. I am going to move through my slides very quickly because I really want to engage you all. I think there are a lot of very intelligent people here in the audience, and there's nothing better than talking about a case that couldn't be more important and couldn't be more on point here, having just witnessed the oral arguments last week. But let me bring you I was charged with providing you more with the nuts and bolts of data, how we use it, how it's collected, who uses it, and then I want to provide just an overview of how we got to where we are today, what led up to our case as a full plaintiff in the case before the Supreme Court last week. So let's start then with some data 101. And what we have, and there's a lot of confusion, maybe even in the audience today, and certainly even among people who are very active in privacy and healthcare information space, about which kind of data that are we talking about here. There's data this is data from actual prescriptions. It's de-identified to patients, but identifiable to prescribers. It's the last is such data is not subject to HIPAA. So under HIPAA, health data is identifiable. It's data that contains patient names, addresses, dates of service, for example. That's called protected health information, and is subject to all sorts of restrictions on access, use, and disclosure. The data, though, is stripped of identifiers, which is useful for a number of important purposes. It's exempt in whole or in part from the regulation. But specifically, data is considered de-identified if it's been stripped of these identifiers and there's, quote, no reasonable basis to believe that the information can be used to identify an individual. So, but it can be de-identified in two ways, or there are two methods to de-identify data. The first is called the statistical de-identification method. This is where a qualified statistician determines that the risk is very small, that the information can be that can be used alone or in combination with other reasonably available information. And the second is and that's the method that we use at Wolters Kluwer. The second is the safe harbor method, which requires the removal of 18 specific types of identifiers. But under either method, this is what we're talking about today. Oops, excuse me. So, protecting patient privacy in the digital age, it's not only possible, but it's necessary to ensure confidentiality while also enabling the essential unimpeded flow of information for quality health care, patient safety, and medical research. Federal law provides strong protection of personal health information through HIPAA, as I've just described. We at Wolters Kluwer Pharma Solutions, we've collected, aggregated, and analyzed approximately 3 billion with a B prescription transactions annually over the last 20 years. We've not had a single HIPAA breach or violation. Here we go. All right. So how does it all work? This is okay. I'm on the right slide now. Okay, thank you. But we okay. Let's move on here. I'm sorry. Here we go. Okay, we are just to back up a little bit, we're a business associate to covered entities under HIPAA. Those of you who are familiar with the HIPAA law will recognize that we're considered a business associate. We're contractually obligated to comply with HIPAA privacy and security rules. And we comply with all sorts of state regulations as well. We employ a chief privacy officer and a chief privacy counsel. We have a privacy review board. I go into this detail because I think it was glossed over a little bit with the previous speaker. This is a very complicated process. We don't just say you collect the data, doesn't do it justice. We use, as I said, we use the statistical method to de-identify the data. But our de-identification process is very rigorous. It begins with all protected healthcare information that's encrypted prior to or even receiving it or immediately upon receipt. It's automated. There's not even a person involved. There's no manual intervention required. We own the intellectual property rights to this encryption module. But we receive it, it's validated, it's cleansed, we have a quality control process, and then, so it's a very robust method that we go through. And we just on the prescriber data, there's over 41,000 retail pharmacies in the United States. That represents 80% of all retail activity. And over 8,300 hospitals, we get data from them, from their pharmacies on site. We combine that data with data that we get from the American Medical Association, the Osteopathic Association, Dental Association, the optometrists, DEA, physician assistants, nurses, from quite a wide variety of groups who share their data with us, and we combine it together. So that just gives you a snapshot of how we use the data, how we combine it and clean it, aggregate it, and analyze it for our clients and customers. It's a very robust process. It's a very large database. This was mentioned by the previous speaker as well. Our database represents 80% of all retail prescriptions. That we have a very complicated, very robust projection methodology where we can project to 100% of all prescriptions. If you take the Medicare database, which is probably the next smallest database from public data, guess what? It's only the Medicare population. We've got a nationwide, our database is nationwide, includes data across the nation in all different age groups, not just the Medicare. So that's one way that we're different. But who uses this data and why? This is we provide prescriber-identifiable data to biotech firms, pharmaceutical manufacturers, distributors, government agencies, healthcare groups, researchers, consulting organizations, the financial community, Wall Street, manufacturers of generic drugs, pharmacy benefit manufacturers, and others. Some of these entities use, license, sell, or transfer the information to identify physicians who may be interested in learning more about their own respective products. We've got several physician groups who purchase our data to see how to examine the prescribing practices of their own membership to know where there might be some issues where they could tailor a continuing medical education program to their membership, for example. While others, academic and medical research, humanitarian organizations, law enforcement agencies, the information is used for many, many ways. But it's not only used by pharmaceutical and biotech and medical device companies, but also providers, government agencies, the Food and Drug Administration, Department of Defense, DEA, CDC, academia, researchers. These data are used to monitor and manage the safety of medications, conduct clinical trials, implement drug recalls, rapidly communicate information to doctors about innovative new treatments, and conduct public health studies. So you're getting the idea. It's a wide variety of people who use this data and for a wide variety of purposes. But so obviously there are numerous uses for the data that serve the public interest. Further the government's mandate for greater transparency in medicine and support for pay-for-performance initiatives, if you will, intended to improve the efficiency, quality, and cost of health care. So importantly, all this is due to the legitimate commercial use of the data. I talked about how big our database is. You can imagine how expensive it is to keep it up to date, maintain in a rigorous way, maintain it. That's not an insignificant undertaking. So let me talk for a minute about the what's going on and how we got to where we are now. The use of the restrictions on the use of HIPAA de-identified data started out 5 years ago. It's remarkable for a policy issue to be so young and have already made it up for review before the Supreme Court. But it started out 5 years ago. Actually, it was brewed up over in California. But we can all agree that the states states are under a lot of pressure for budget reasons. They're trying to create revenues is one of their top priorities. They look at managing healthcare costs is probably their second priority. So they over the past several years, they've been looking for ways to look at drug marketing and contain the costs for their own programs. Some of the ways that they've been looking at drug marketing have been gift and payment bans, disclosure of gift and payments, licensing requirements of drug detailers, which is right here in the District of Columbia, academic detailing programs, which we endorse and think the academic detailing is a great way to go. The interesting part, though, is if the state has an academic detailing program, they're still probably going to use our data to analyze whether the program is even successful. Now, academic detailing, for those who don't know, is where the state hires physicians and nurses to go visit doctors and make sure that they have the most up-to-date clinical information that they have. And what's interesting though is to be able to measure if these programs are successful, is they'll still need our data to know which doctors to go and visit and to educate. But anyway, there's a wide variety of efforts on the state level to look at drug marketing. Restrictions on the use of HIPAA de-identified prescriber data is one of them. Common themes that we've heard among the lawmakers, and these are direct quotes from many of the groups who have been on the other side of this legal argument than us. Doctors or state lawmakers have been worried about undue influence on doctors by drug retailers, vexatious and harassing practices was how they've described it, or undue influence. They maintain that many of our opponents maintain that the use of our data allows drug companies to unduly influence doctors to prescribe brand name drugs, which are more expensive than generics, for example, so it leads to higher costs. Interesting argument, but these laws, at least in New Hampshire, Vermont, and Maine, have been on the books for several years. We've not seen any evidence that the use of this data has added to healthcare costs 1 cent. There's no evidence that it has increased costs at all. Patient privacy, this isn't about patient privacy. I'll say it once, I'll say it again. This is not a patient privacy issue. Physician privacy, I think we heard last week from the Supreme Court, they're not inclined to agree that physicians have a privacy right to this either. And then there's a program that was developed by the American Medical Association called the PDRP program. It's the Prescriber Data Restriction Program, where doctors can go on the AMA website and within 3 or 4 clicks can say, I don't want to share my data. I don't want my data to be shared with drug companies to share with their sales reps. So it's a private sector solution, seems to be working very well. 27,000 doctors have already chosen to opt out of the program. And we say that, let doctors choose how they want to deal with this.
That's good.
Sure. Let me just, my next slide, and feel free to go through them here. Who's driving the legislation? This lists all the different groups who are involved in the case. Many of these groups filed amicus briefs on both sides last week. We've seen a wide variety of bills floated in the state level. Here are some variations on it. Last state legislative session, there were over 40 such prescriber data restriction bills introduced in close to 20 states. Not so many this year, but I think that has a lot to do with the waiting to see how the Supreme Court's going to handle it. And then I've provided a little bit more detail in my remaining slides about the cases and the laws enacted in New Hampshire, Maine, and Vermont. It's the Vermont law that was before the Supreme Court last week. And each law is very different, but it's worth noting that of the several dozen states who have considered legislation in this arena, only 3 have actually enacted laws. Thank you.
Thanks. Go ahead.
Great. Hi, everybody. I'm Ann Waldo. Glad to be here. I'm pretty passionate about this topic, as you will see as we go forward. So I also have at least 2 hours of content that I'm going to try to deliver in about 15 minutes. So hang on for a wild ride. I want to say a word about my role. I helped with the preparation of the amicus brief, the Friend of the Court brief for Genetic Alliance, which is a health advocacy group headquartered here in town. I do some pro bono work for them and did so in this case. I'm also part of a team in our law firm providing government relations services to Wolters Kluwer PharmaCert Solutions, so I'm familiar with the issue for that reason, and really I can't guarantee that my views today will represent those of either client, because I've also worked in this space for more than 10 years in a whole variety of different jobs. So these really are my views, which are likely to correspond with my clients, but not necessarily. So I'd like to do something I don't think I've ever done in a presentation before. I took the questions from the event promotion, and I, as a little teaser, would like to answer them for you, given my own perspectives, of course. So, do laws that burden or ban the sale of de-identified data for marketing also impede medical research? Yes. And under the Constitution, can states that want to regulate the conduct of those who use data do that regulation indirectly by restricting the factual data itself? Again, I say no, and the Supreme Court hinted rather broadly, at least a number of members did, that they agree with that position, and we'll see what the Supreme Court says, because my opinion is just my opinion. But there certainly was strong evidence last week that some of the right people agree with that opinion. What would be the real-world consequences to healthcare and technological innovation if laws that restrict or ban particular data sets end up surviving constitutional scrutiny? In a word, dire. What privacy angles should be considered with respect to this case? Again, I say only a little bit facetiously, none. And more broadly, is de-identified medical data a public good or private property? The question was raised by our first speaker, a very interesting question. And I just have to say, empirically speaking today, the answer is it is both. You can argue that it should be a little more or less in different scenarios, but clearly de-identified health data in the hands of the CDC is a public good. Census data that may include health data is a public good. De-identified health data in the hands of Wolters Kluwer and other entities is private property. So that is my little teaser. Kathy set up the case nicely. We won't go through this other than to point out that the Second Circuit, the Court of Appeals, agreed that the Vermont law was unconstitutional. We'll get into that more in a few minutes. The trial court had gone in the other direction, and the Supreme Court oral argument was last week. We expect a ruling in late June. This slide might look familiar. Absent the pretty picture, this is the same as Kathy's slide. I only mention it because I really want to pound on the table about this. If you don't remember anything else, please remember this data, the subject of the Supreme Court case, is de-identified as to patients. And I apologize for pounding on that, but I've seen in repeated news stories in the last week that the reporters got this wrong. In fact, one excellent reporter in general had an entire 2 or 3 page article and didn't mention that this data is de-identified. So you will see inflammatory headlines of your prescription records bought and sold, and you'll think that's your name and address, and it most certainly is not. This is de-identified in the technical sense, as Kathy went through, and in the legal sense, and it is not a casual statement that the data has been anonymized. Outside of the HIPAA world, de-identification can kind of be in the eye of the beholder. You can take a name off of something and call it anonymized because there's no objective standard for data anonymization. But in HIPAA, it really does mean something. So, legal issues and public policy issues in the case. I want to be sure and touch on both because, as Dan said in an excellent blog yesterday, just because something is constitutional doesn't necessarily mean it's a good idea. But first, let's talk about the law. In a sentence, the question is: does the Vermont law, written exactly as it is, violate the First Amendment of the Constitution? Of course, if it does, if the answer is yes, then the law ceases to have any legal force instantaneously. Now, there are tons of interesting sub-questions below that dominant question of is it constitutional. For one thing, there's a great debate about what is the right constitutional standard to use in order to judge whether or not this data is constitutional or not. Commercial speech is speech that is about a commercial transaction or proposing a commercial transaction. So the fact that, I misstated, it is not data about commercial transactions. That would be way too broad. It is data proposing or promoting a commercial transaction. So an ad is commercial speech. A stock prospectus is commercial speech. Articles in the newspaper about commerce are emphatically not commercial speech, and there's that's really unassailable under Supreme Court law. So the question then becomes, are these databases themselves full of de-identified prescription data commercial speech, or are they non-commercial speech, which deserves a higher level of protection? Our Supreme Court jurisprudence has allowed something called an intermediate test to be used to evaluate whether commercial speech, i.e. think of it as advertising, can withstand constitutional scrutiny. So if you think about the pharmaceutical sales rep talking to the doctor, that's undeniably commercial speech, or at least I can't see how to make an argument that it's not. They're promoting a commercial product. But is the database behind it, which is just objective facts, commercial speech or not? It certainly seems reasonable to me that it is not commercial speech and should be subject to the higher test. It actually doesn't really matter for the purposes of the outcome of this particular test, this particular case. It will matter in other settings, to be sure. In fact, not even all the parties on the same side, all the amici, the friends of the court, are in agreement about exactly which test to use. The point is that even if you use the lower test, the intermediate scrutiny for commercial speech, there's an awfully compelling argument that this law, this Vermont law, would flunk that test, and which is, of course, what the Second Circuit ruled. The Second Circuit said that the only legally recognized, the only cognizable state interest was in reducing the costs that the state has to pay by promoting more generic drug use. The state had advanced two other purposes, advancing public health and protecting doctor privacy, and the Second Circuit said no, those didn't qualify. The Court of Appeals also ruled that the law did not directly advance that interest because the law attempted to influence prescribing behavior, conduct, we'll come back to this, by regulating data. So that hook of trying to affect conduct by going upstream and trying to choke off the data that's used to make that conduct perhaps better informed or more efficient is certainly highly suspect under the court's jurisprudence, which leads us to the Supreme Court. So what happened last week? A number of us here were there. It was wonderful. It was extremely interesting. I would recommend that if anyone has taken the time to come here today or watch this online, that you Google or you click the link in the last slide where I show I have the link for the Supreme Court transcript itself, which is well worth the time to buzz through that. It's absolutely fascinating. The justices were surprisingly well prepared, and some of the questions went absolutely to the heart of the matter. All right, I'm switching to a bigger version of my slides here. Justice Scalia, for example, said, let's not quibble over what the purpose of the law is. The law's purpose is to impede the marketing of drugs. That's actually crucial. What is the law's purpose? Because if the purpose is to affect conduct and yet you're going upstream, as I said, to restrict speech, that's problematic. The law also was quite strongly implied to be discriminatory in its effects and even in its goals. The discrimination comes in insofar as the data under the Vermont law can be used for any purpose by anybody except by pharmaceutical companies for marketing purposes. So literally the data could go to a different recipient who could put it out on the internet, and that would be legal under the Vermont law. So clearly it does, which gets at another infirmity of the law, that it doesn't protect prescriber privacy at all. Whether or not you think prescribers should or shouldn't have privacy rights, and that's highly debatable in their professional conduct. I can make a strong case that they should not. But even if you thought they should, this law doesn't advance that interest. Justice Ginsburg stated it well by saying, the government really isn't allowed to set different decibel levels among speakers. The government just simply can't put its thumb down on the scales in the marketplace of ideas. There was skepticism among the court that the law had used the least restrictive means, which is one of the things you must do even for this intermediate test. Justice Sotomayor, I think, very crisply went to the heart of the problem when she said, why didn't you guys just enact an opt-out? And not realizing that what you folks now know, that there already is an opt-out and no enactment of an opt-out is needed, it already exists. But she said, couldn't the vast majority of the American public has already registered their telephones on do not call lists. Do you really mean to say that doctors couldn't be told how to register themselves somewhere in an opt-out? Why do you have to go all the way to an opt-in? As a privacy lawyer, I was thrilled that the Supreme Court's talking about opt-ins and opt-outs for the first time ever. And then Justice Scalia really went to the heart of the matter when he said, why can't doctors just say go away to a pharma sales rep? And the answer is, of course they can, and of course they do. And several jobs ago, I used to ride with reps now and then. I was thinking this through this morning. I bet out of about maybe 30 sales visits, so I've got an N of about 30, I'd say maybe 10 to 15 times the doctors just said go away. And these are doctors who didn't even have a policy of saying go away, which is, those you can't get in their door at all. But these were just doctors who were too busy. And they're like, sorry, no time. And out of those that remained, I'd say the majority gave the sales rep less than a minute, maybe less than 30 seconds. The sales rep would be like, I've got some new data about the safety of my drug. Doctor, can you please take a look at it? And he's like, I'm incredibly busy. And the sales rep says, please. And they say, okay, I'll take your papers, go. That's a pretty typical pharmaceutical exchange. And I think it's actually imperative for patients, given how scarce that time is and how expensive those visits are, it's really good for the system as a whole that those visits be efficient. I don't think anybody is served, certainly not the patients or the public, by having those visits be targeted at the wrong doctor. So there are other arguments, but I'm going to have to zip forward because I want to be sure we talk about the public policy perspectives. It might be possible to rewrite this law, and perhaps after the Supreme Court's decision, we'll see further activity in the states where it would be less clearly subject to a constitutional attack. The justices seem to be almost mocking the law and mocking the legislative findings. There were some amazing things in the legislative findings saying essentially we want to interfere in the marketplace of ideas, which is code word for danger in constitutional law. So the question is, even if you could write a law that would pass constitutional muster, should you? And now I really am going to wear my Genetic Alliance pro-patient hat and say, my personal opinion is absolutely not. You should not enact restrictions like this, even if you could find a constitutional way to do it. First of all, I don't think in this particular case they're needed. Both the Court of Appeals and the questioning of some of the justices, Justice Ginsburg in particular, seem to be saying that the only real legitimate interest of the state was in trying to reduce drug costs by promoting generics. There was so much emphasis on that in the amici briefs and in the press that I went back after last Tuesday and did some research on the use of generics and found that generics make up 78% of all new prescriptions filled in 2010. Even when the doctor writes you a name brand, this has happened to me probably twice this year, doctor writes a name brand prescription on the pad, you go to pick it up, you get the generic. The generic substitution has become extremely efficient, and it's promoted by insurance companies. And it's mandated by insurance companies and by PBMs, the pharmaceutical benefit managers. So these generic substitutions already occur with great efficiency routinely, and generics are growing at a rate. Overall generic spending, despite the fact that generics cost less than brand names, has grown at 22% last year, while brand name sales have declined by 1%. That's largely a function of how difficult it is and expensive to create new drugs. Again, wearing my patient hat, I'd certainly say that the most expensive drug is clearly not always the most expensive treatment remedy overall. An expensive drug can prevent a far more expensive surgery, and there's lots of information about that. But then again, I don't think that what's cheapest is necessarily what we want as a society. To take it personal, I've got three close friends in the last couple of years about my age who've been diagnosed with really bad cancer, and we've already lost one of those friends. If that were your loved one or that were you, and there was a drug coming down the pipeline, and that drug ended up costing some money, wouldn't you want it to be available? Isn't that actually the whole reason that we have biotech industries and pharmaceutical industries, so that they will bring breakthrough new meds to market to help all of the rest of us and all the people we care about? So I just, emphatically renounce this whole idea that we should always go with what's cheapest. We actually should be in the business of, obviously costs matter, but we should be in the business of trying to help people. Death is always a cheap option, but not necessarily what we want. There are thousands of conditions for which there is no treatment available. The CEO of Genetic Alliance, Sharon Terry, has 2 children who suffer from a rare genetic disease. She's also the CEO of a nonprofit that tries to advance treatments for that disease. There is no treatment available for that disease, none at all. And she's been working tirelessly for 15 years to try to get there. If a treatment were to be developed, and I were she, I would want sales reps to be targeting the right doctor with the best possible information, getting the information out fast, because years and months and even weeks can really matter. And I apologize if I'm kind of going on my emotional soapbox there, but I really do think that was missing from a lot of the dialogue about how anti-patient it is to say somehow that it's best for everyone to slow down the uptake of new drugs. I just emphatically reject that. And along a similar vein, the state's brief said that it advances public health if you slow down the uptake of new drugs. And as evidence for this, they cite the fact that a couple of drugs, Vioxx being the most famous, have been pulled off the market in recent years because of safety issues that weren't evident until they were used by a very large population.
And let me just give you a second to wrap up.
Okay.
But we're going to pull Mark back in so we can.
Great. Well, the next 2 slides I'll slip past, but I'm happy to chat with people afterwards. And it's not about prescriber privacy. The AMA opt-out has, only 5% have exercised it, and 96% of those surveyed of physicians say that they're satisfied or very satisfied with it. It's certainly not about patient privacy. We could have an entire session on de-identification and re-identification. And I also want to make it clear that this case is not about all privacy laws. We're seeing some indications of that in the press. There were comments in the amici briefs that if this law falls, then HIPAA is going to fall and other privacy laws are going to fall. I would love to talk with folks offline about that, because I have a lot of opinions along those lines. I think it's very easy to distinguish this case from HIPAA, first and foremost, because the data subjects here are not patients and consumers. That's the bottom line, the identifiable data subjects. But there are plenty of other reasons too. But I think the bottom line is that even privacy laws have to be balanced against other First Amendment interests. And so if a privacy law does impede speech, then it should quite appropriately be subjected to either intermediate scrutiny or strict scrutiny, depending on the type of speech, and almost all privacy laws will survive that. In fact, HIPAA's already been adjudged to survive it. We have broad implications for technology and innovation in general. The chief one being, and this really is where I'll close, that I think you can go away and ponder this as you're walking down the street. What would happen if we chose to, as a society, block data when our goal is to restrict the conduct of the users of that data or the consumers of that data? If you take real estate data, there have been terrible examples of realtors using real estate data to engage in blockbusting. You knock on the door and say, did you know that certain elements are moving into your neighborhood and maybe you should put your house on the market? A reprehensible practice, an illegal practice. But should society's response be to ban the MLS database? Or should it be to restrict the offensive conduct? And you can go through Facebook data, which can be used in bullying and cyber stalking and so on, and again say, should we ban Facebook because the data can be abused? The BBC wrote in one of the pieces last week that it's not hard to see that the Vermont case is bigger than just a legal fight over what to do with information about prescription drugs. And that is certainly the case. I'll leave it there.
Great, thanks. And Mark, we're bringing you up right now. See if you're. There you are. Okay, so we're going to open this up to questions in a minute. Mark, I wanted to give you a chance since you started. If you had anything you wanted to respond to specifically from the panel, and I'll give everyone else on the panel a chance as well if you want to have a little bit of dialogue. And then, of course, we do want to make sure everyone has a chance to ask questions. We have a lot of interested people here in the room.
Well, a couple of things. I'm not don't want to portray myself as a privacy advocate, and as I mentioned, I think that there are problems with privacy, both whether you call it private or not public, and what are the schemes. But to be honest, I think it's a little glib to say that we have de-identified, anonymized data, and so there are no privacy concerns. There's a whole literature, and the experts I speak to in this say that it's almost impossible to fully ensure privacy anymore, because what you do is you take the anonymized data and then they can cross it with other databases, and people can reconstruct information. So if you know something, say, about the pharmacy or the doctor, and get de-anonymized data, there are risks. Now, I agree we shouldn't stop all progress or use because of that. In fact, I think one has to balance the private interest in privacy and the public value that comes out. But I think we ought to admit that there's some issues and not say, once it's de-anonymized, it's fully safe.
Well, let me let Kathy respond to that.
I'd like to point out the literature and the people who are experts that write on this.
Sure. Let's just stop there and or let Anne respond.
Sure thing. That was in my slide set that I didn't get a chance to go through. There there is indeed a lot of literature, and that's why I said I was being a little facetious in saying there are no privacy risks. There's actually a much more nuanced answer that we could spend all afternoon on. HHS had a 2-day workshop last spring on de-identification, so there's obviously a lot that can be said and written about de-identification. And I agree with you that that any risk of re-identification that is identified does need to be put in the context of the benefits to society. I think that's very important. I would also say that I agree with you that we certainly can't claim that the risk of re-identification is zero. There aren't very many activities of human contact where the risk is zero, and I think we should be rational about those risks and evaluating the benefits. But the statisticians in this space do not say it's zero, and then they argue over how many zeros you put after the decimal place before you get out to what they think that risk actually is. But the risk is clearly minuscule, and there has not yet been a published case of a HIPAA de-identified data set that has been successfully re-identified, despite the fact that there's a challenge out there. And I want to make sure we skewer a couple of misperceptions in the literature, especially the popular literature about de-identification. There's a very famous case from 1998 where a professor, LaTanya Sweeney, currently at Harvard, re-identified some individuals in a health data set that had been released by the government of Massachusetts. We could talk about that at great length, which we don't have, but the takeaway is this data set was pre-HIPAA, 5 years before HIPAA, and it would not have come close to satisfying the HIPAA standard for de-identification. That data included more than 100 attributes per care encounter, which makes an incredibly granular data set, and most important, it included zip code and date of birth and gender. So she was able to exactly do that Venn diagram intersection with a voter registration database that she bought for $20 and re-identify some people, including Governor Weld, where she famously sent him his medical records in the mail. There are also good ways to distinguish between the Netflix and the AOL recent re-identification cases as well. Most importantly, that those aren't subject to any objective standard.
Sure, and I'll take off my moderate. Yeah, I'll let you go. Go ahead.
I agree with you, but there's a kind of imbalance, and I don't want to be in the position of defending the plaintiffs in this lawsuit, and I'm not against the other side. I am just less familiar. But in my experience in sitting in and participating in the Markel Foundation, Connection for Health, and in other groups, folks that represent and work with the data banks, the de-identifiers, the markers, all those groups, spend an awful lot of time trying to insert clauses in that would end all liability for breach for those groups. And that's a change because currently, with paper records, there's not an exclusion or end of liability for breach. So there are two things. That suggests to me that those who are working on the industry realize there's some real risks and they don't want to bear it. But secondly, even if it's small, if they're common benefits, I think there should be common sharing of the risks. Now, I don't know what they are, but it seems to me that there's a very efficient way to do that. Build in whatever the cost is through insurance, charge the data that will cover the loss of risk, pass that on to the users. So if there is a real risk and someone should be compensated, there's a mechanism to do it rather than say, we're excluded from liability. And I wish the industry would say and step up and say, we're so confident of this that we're willing to do it. But in fact, they've done the opposite. And I think you'll get a lot less bite back from the privacy advocates that, in my opinion, sometimes are unreasonable if you take that position.
I think that's a great point.
I have a question that I wanted to ask, and as I said before, I do want to open this up. So let me start with my question, then we'll go forward from there. One question I had, I guess this is for Anne, and then I have a question for Mark specifically. For Anne, let me go ahead and ask first. You started to get into this, and this was a little bit in your slides, but can you talk a little bit more about how you think new technology will change, and this for you as well, Kathy, how new technology will change the current processes? Because it seems with the introduction of especially e-prescribing, new mandates that could come out that could, for example, right now you have to have prescriber-identified prescriptions because we regulate drugs, but it's conceivable to have anonymous or anonymized prescriptions where the prescriber's name is encrypted and potentially held in a government database that the government has access to. So there's ways of taking this data out. There's ways of creating new intermediaries. How do you think that will change the current market, the current way the industry works, and how will that data or loss of that data affect you?
I think it's a fascinating question. The data analytics is exploding. Just about as fast, not quite, but just about as fast as the data storage capabilities. And so I think we're going to see some real innovation with respect to de-identified data. Kathy did a great job of explaining to us how expensive and complex the process is today, and part of that is because they use what is generally regarded as the more robust statistician method. So you have to have a human being involved that crunches numbers and makes real judgment calls. Could that become more automated in the future? I'm certain that it could. I think it's a fascinating area for computer science research. I don't know that it leads to any other particular conclusion here, because I think you still have the same policy questions about when should data be identifiable and non-identifiable. I think we didn't really get into the benefits to society if prescribers' identities are in fact transparent, but that's actually very important for all sorts of quality and safety reasons, and drug abuse enforcement and so on. We're certainly going to be seeing under the Affordable Care Act an enormous groundswell towards more transparency and more data analytics on a larger scale. As a privacy person, a privacy professional, I very much want a lot of that data to be moving in the direction of less and less identifiable. So I think there's a lot of cases where fully identifiable data is used today, where a limited data set would work. That's a special HIPAA subset of partially anonymized data. And I think we're going to see more and more progress toward automation.
Mark, I wanted to ask you if you would extend a little bit. Your proposal that you presented is really all about anonymized data, correct?
Correct, yes.
So can you talk a little bit about how you see the use of non-anonymized data or patient identifiable data, in some cases prescriber identifiable data in other cases, how you see a market for that? Because it seems to me at least that there is, just as there are many uses of the identified data, there are of course many research uses of identifiable data as well, including many that exist today.
Yeah, let me just, can you hear me? Because I put something to lower my microphone before and I can't find it to put back.
Your sound's good.
All right.
We can hear you.
Okay, no problem. Well, my hunch is that you have a much larger market in anonymized or de-identified data because of the restrictions on identified data. And so that's my main concern. If people voluntarily want to give up their data, I think that's fine. But there is this massive database out there that can be de-identified. And so I guess I'm trying to get I'm not sure what you're trying to get at. Would there be different uses or proposals?
Well, I guess what I'm asking is, I think you do make a compelling case that there's a public interest in using medical data for research. And I guess my question to you is, your proposal just looks at de-identified data. I would think there's a compelling argument to be made for using patient identifiable data as well.
Right. Well, in a sense, there's always been informal learning and use of data that doctors have, but there's a whole range of other privacy concerns. And so I tried to limit my remarks to this massive use of de-identified data that's growing and can be sifted for population studies. And I really want to leave. Yes, there may well be a public interest in using identified data, but there are countervailing interests in terms of privacy and use. And so I think we can put that aside for the moment, because it's a smaller issue in terms of market, because most of the people in the field are saying they're going to protect confidentiality. And I don't want to slow up where there's more likely to be agreement and development because of some residual issues for other data.
Okay. I'd like to open it up, so if you have a question, please just, if you say your name and any affiliation.
Bob Gelman, I'm a privacy consultant. I've got a question for Kathy and Ann. I want to spin out a hypothetical and see what you think. Suppose the Supreme Court throws out the law and the state legislature says, well, we're going to pass a new law, and we're going to instead of relying on the opt-out that the AMA runs, we're not even going to put in an opt-in. We're going to have an opt. When you renew your medical license, you must check a box, either yes or no. And suppose they do that. The question is that okay? Does that pass the constitutional test? And suppose half the doctors then opt out. What does that do for you?
Everybody hear the question? Okay.
Yeah.
All right, thank you. I'll take a quick stab at it. It's an interesting idea, but I think that's what we're already facing. The statute of Maine is an opt-out or opt-in. Vermont's an opt-out. So it's between the two. We're already facing that dynamic, and I don't think it improves the chances of the law having constitutional muster either.
You mean so that if the state merely said to doctors, you must make a choice between one or the other, that violates the First Amendment too?
Because they're still restricting the use of the data.
The Constitution requires an opt-out rather than some other way of getting an opinion. Is that the argument?
The argument is that the Constitution requires that any law pass at least the intermediate scrutiny test, and the way you pose it, I don't think that law would come any closer than the existing law, or maybe it would come a smidge closer, but still fall short. The question is, if this is speech, then does suppressing it advance a substantial state purpose? And I don't know what that substantial purpose would be, because as I said, generics are already winning the battle without any state intervention. And does the law directly advance that purpose? And does it use the least restrictive means? And I think that a mandatory opt one way or the other would flunk that test just like the Vermont law does.
So you are saying that an opt-out is constitutionally the most you can do?
Well, remember that the opt-out that exists today was not mandated by any law. It was something that the several industries actually, pharmaceuticals, the data analytics companies, and the AMA got together and tried to come up with a solution that would satisfy the doctors that were unhappy without, disrupting the entire data sets which are needed for so many valuable services. You know, with any kind of opt-out law where research is involved, the greater the number of people who participate in the opt-out, obviously the less quality the data set is at the back end of that. And so, but bear in mind, there wasn't a law that said they must have an opt-out.
So then a law that said there has to be an opt-out would be unconstitutional too.
I think that's a great question we can play with. But clearly, many decades of Supreme Court jurisprudence would tell us how to answer that question, and it's going to be those same things. Is it the least restrictive way for the state to try to accomplish its goal? Anytime the state wants to burden speech, that's what it has to do.
Okay.
And I'm so tempted to get involved. I mean, it seems, clearly the state was making a choice here to restrict one kind of speech and not other kinds of speech. So doctors are being asked, so in your hypothetical, is the doc being asked to opt out of the collection of any data for any purpose? That is to say, for public health, for quality monitoring, for all the other uses that their data has? Or are you asking the doc to opt out only in terms of marketing? So you're actually asking for an opt-out that affects only one kind of speech as opposed to the other kinds of speech.
Yes.
Okay, gotcha. That's
Go ahead.
I wanted to ask Ann, John Camp, Coalition for Healthcare Communication, Ann or Kathy, Ann particularly, to connect the dots for me between patients and these kinds of laws.
Got an hour?
I don't think so.
No, I'm afraid not.
15-minute version, 5 minutes, 50-second version.
I'll try to be more concise in that. I think patients benefit from the non-existence of restrictive laws like this in a number of ways. One is, I think all patients, and we as taxpayers as well, benefit when we have a far more data-rich environment with robust analytics being performed. And I think data fluidity is a very good thing. Now, like other interests, it has to be balanced with privacy. So data fluidity and data privacy are often in tension, and so we have a lot of work to do to figure out where the right place to make that balance is. But there is so much potential for patients to be benefited by being able to do medical research at a more efficient and larger and grander scale than has ever occurred before. And there's some really exciting work being done where pharmaceutical companies, for example, are agreeing a little bit, tentatively, but are beginning to agree to open up all of the clinical data from the placebo arms of their clinical trials and share it with their competitors and share it with nonprofits who can perform metrics and analytics on this data at a level never seen before. That has the potential to take cost out of drug development in a radical way. There's great crowdsourcing with medical data, websites like Patients Like Me, where tens of thousands of people voluntarily put their medical data up so that research can be done on it. So I think we all stand to benefit by taking data fluidity to the greatest level that is rational and protective of legitimate privacy interests. And you certainly always have to bear that in mind. Patients also benefit, however, by, and I know not everyone would agree with this, but I think patients really benefit when the right doctor, when the most relevant doctor gets the word about new drugs as fast as possible, as efficiently as possible. I don't think it does anybody any good to make drug companies spend more money on marketing. And that's what they'll have to do if this data doesn't exist, and I'd say that whether I was working, for anybody in the world, who my client is, I just don't see why we think it's a good idea to cut off the information available to them so that they waste money on marketing. And I just read in preparing for this that there's evidence that in Vermont, pharmaceutical marketing costs have gone up since the law was in effect because they're forced to kind of do their marketing in the blind.
It's especially important to small biotech firms who using this data is just about the only way that they can compete with big box pharma, if you will. They don't have the resources to identify which 10 doctors out of 10,000 in a state are interested or to even treat patients with this particular condition. They need this data to be able to focus and to identify and focus just the prescribers that they want to talk to. So it's a competitiveness issue too.
Please go ahead.
I have not a question, really, kind of a statement. But as a consumer, I would want to know if my doctor was not receiving this information, because I have so little information really about my doctor anyway. I would be really concerned that my doctor would not know the latest medications help out there. And I mean, would you, if a doctor opted out, would you allow consumers to know that? Or would they have a way of knowing?
That's a great point. I've actually never heard that before. That's fascinating. But I can tell you there are going to be a lot of new information about doctors will be publicly available under the Affordable Care Act. There's a website called Physician Compare, which was launched January 1, and it's right now got very rudimentary information. But by 2013, it's going to have information about patients' surveys about their experience of care, and we think that over time that's going to become more and more robust. And so you could make a pitch that you also want to know if the doctors are getting educated about new drugs.
Well, the line is
Can I respond to this
It's so
concern?
blurred here.
Yes, go ahead.
Sure.
The issue is a little bit more complex than getting access to doctors to get them the right information. The problem is that doctors that aren't appropriately prescribing drugs, aren't getting the information, but at the same time, there's also the risk that marketing and contact will induce doctors to prescribe the drugs for inappropriate uses. You can argue about the percentage of it, but there's a fair amount of evidence, and all the incentives are to market and sell the drug regardless of whether it's for inappropriate or appropriate uses. For example, sales representatives get rewarded based on increased sales for doctors in their area. And I've proposed to some people in the industry when I've talked to them, some presidents of companies in Japan, pharmaceutical companies, why not adjust the incentive so that it only doesn't reward off-label use or inappropriate use or inappropriate marketing. So the point is, yes, we want information out. Yes, we should be concerned about marketing costs. From a consumer perspective, you should worry about whether your doctor is getting it only from the pharmaceutical companies. There are whole purchasable databases and newsletters that analyze the risks and benefits of drugs much more effectively, and they're a much more reliable source of information. From the 1930s on, the AMA and other groups have decried the problem that doctors get most of their information from marketers and said that they need to get better and independent sources of information. And there's a terrible imbalance now where there are billions spent to market drugs. It has some beneficial effects. It can get doctors that underprescribe to use it, but it also has the other problem. So we ought to keep that in mind and not suggest that there's only risks or problems in not getting the information out.
Thanks. I think we have time for two more questions, but quick questions and quick answers. So.
Name's John Moore. I'm with a startup electronic medical records company, and it seems to me that the direct provision of information about drugs and stuff can really be built into a good electronic medical records system, so that when there is a patient problem, the information gets to the patient, not through a salesman, but directly. And I suggest that that argues for a more public database, along which Mr. Rodman is suggesting.
And I'll just add, I was at my doctor recently, and I asked for a refill of a drug, and she said, "No, my EMR just told me that you're probably allergic to that drug." And I said, "No, I'm really not. I've taken it a number of times." And she said, "Well, the evidence says that if you have these other features, you may well develop an allergy. So I'm not going to give it to you." And I said, "Well, no, come on, give it to me. It's I've used it. I'm fine with it." And she said, "No, I'm going to listen to the evidence, and I'm not going to prescribe," which was exactly the right decision to make. So. There's no question that clinical decision support can be a really good thing, even if I didn't get what I want.
Just to follow on to that comment, and it's really kind of a question for Mark, I think, primarily, which is so if we assume that and I'm Doug Petticourt, and I'm actually thought I would talk about clinical research, but I'm mostly going to talk about AMIA and medical informatics. If we assume that data extraction and aggregation of de-identified data is actually expensive, it is not without cost, then Mark, how do you deal with what certainly hospitals and physicians would perceive as yet another unfunded government mandate for them to in fact provide what would be costly to them data for a publicly available database, for which then there are lots of other nice uses. But it strikes me that your proposal removes the little bit of proprietary interest that any given large hospital, for instance, would have in its data, and then in fact it's the lack of proprietary interest and the lack of financial incentives today, which is very much in the way of data fluidity. And the reason that we don't have data fluidity is because we have proprietary EMRs, but so one hospital can't talk to another, and we can't incentivize hospitals to in fact upload that data to some central place like you'd like them to. So I'm just wondering about who's going to pay for this? I mean, it's clearly an unfunded mandate on hospitals and docs, so how do you get them to do it?
Well, those are reasonable things, and one would have to look carefully. But keep in mind, there's certain information that is already uploaded. Right now, to get billed, hospitals and doctors provide lots of information, right? To bill, they have to report the patient, the diagnosis, whatever. And so, at least for reporting certain kind of things, we're not talking about collecting or doing much more. If it's not the case, we might have to compensate, but I don't think it should be in terms of ownership, but in terms of the transaction cost. You also need to understand that people who use the system benefit also, and they don't pay for the benefits, right? The hospitals, the providers, the patients benefit from knowledge that develops, and they don't pay each time they get a public benefit or a public safety. So it works both ways. And in fact, if you're going to make your money off the system, you assume the system's there. And certainly if costs are low or non-existent, I think there should be obligations. We do this in other areas. And also you have to look at what the alternative is. As Amy, a lot of these other groups say the government, the public health authorities should have to buy this data on its own. And so the flip side of the unfunded mandate for those who work in the system is the unfunded ability of government to fulfill its function of public safety and protection.
Great. Well, we're over time. I said we'd stop at 4:30. It's 4:34. So I'll stop, but please join me in thanking our panelists.
Daniel, are you going to circulate their presentations and contact info?
Yes, all of the presentations are on our website.
Website.
You can download them there, and the contact information is on there. The video will be posted as well after.
Thank you.
Thanks.
And I put some links at the back of mine to some of the better news stories and blogs as well as the transcript.
Thank you.